Good afternoon and welcome to an oral argument session at the 5th District Court of Appeal. As announced, I'm Alan Lawson. I'll be presiding today. To my right is Judge Evander and to my left, Judge Edwards. We have two cases on the afternoon docket. The first is a juvenile case. Each side has 15 minutes. The second is a civil case, Knight News versus University of Central Florida. Each side has 20 minutes. If you are the appellate in the case, the way our clock works, if you haven't been here before, is that you'll have a clock in front of you. It'll count down from your allotted time. And if you want to try to save time for rebuttal, let me know and I'll set it so that the light on the clock goes from green till yellow when you're in your rebuttal time. But I'm not going to save it for you. So if you use the whole 20 minutes, there is no time left for rebuttal. So you're sort of responsible for that. I'll try to help you in that way. But we'll call off the first case, MM versus State of Florida. Counsel will come forward, get set up, and as soon as you are ready, we are. Mr. Fawbush?
May it please the court? Good afternoon.
Would you like to try to save some time for rebuttal? We'll do that before we start.
Yes, please. If I could save 5 minutes for rebuttal.
Okay, so the light will turn yellow when you're into that time. Got it?
Okay, thanks.
Okay.
My name is Andrew Fawbush. I'm an assistant public defender from Orlando, and I represent the appellant. In this case, we're asking the court to reverse the trial court's ruling as to the judgment of dismissal as to count 1, trespass upon school grounds, because the record is devoid of legally sufficient evidence to find that the child trespassed upon school grounds. In this case, a middle schooler, a 14-year-old boy, was sent to the dean's office by his math teacher. In the dean's office, he did not calm down. He used profanity and he was upset. That behavior resulted in a 10-day suspension. After being suspended for 10 days, he was instructed to stay within the dean's office and wait for his mom to come. At that time, he stepped outside of the dean's office for a couple moments. The record is clear that when he was in the dean's office, he was on school property, he was on campus. When he stepped outside of the office for a couple moments, he was still on campus. The state maintains that that step outside of the dean's office, from the dean's office to just outside the dean's office, constitutes trespass on the school grounds. In order to be found guilty of trespass on the school grounds, there are two elements. The first element is that one, enter or remain onto school property, and the second is to do so without authorization, license, invitation, or legitimate business.
Well, let me ask you, can the school restrict what part of the campus you can be on? For instance, if the school said no students in a teacher's lounge, and a student, was instructed on that several times and went into the teacher's lounge, could they be found to have trespassed?
Yes, Your Honor. A school can certainly restrict areas that a child or students that can go to. That could result in disciplinary action by the school, or it could be a simple trespass or a trespass after warning.
Okay, well in this case, if the student is under suspension, and so arguably they don't have any right to be on the campus, but you have to wait for the parents or a parent to come pick up the child or someone to pick up the child, can the school then restrict the permissible area that the child can be in to the office, and that all other portions of the campus were off limits?
Yes, Your Honor, I believe the school can restrict the area that the student can go, especially if they're suspended. But in this case, it was not charged as a simple trespass or a trespass after warning. It's charged as a trespass onto school grounds. And the case law and the statute is clear that the first element is to enter or remain on school property. So you have to either enter or remain on the school property. The child entered the school property once that day, in the morning when he was going for classes. That was when he entered school property. And at that time, he had a legitimate reason. It was going to class. When I entered the courthouse here today, I entered the courthouse property once. When I walked into the courtroom, I didn't enter the courthouse again. When I stepped past the bar up here to argue, I didn't enter the courthouse again. You enter school property once. This statute is for a student that should not be at that school, a student from another school that's there to cause problems and steps onto...
Let me ask you this. You agree, there's no dispute that the state proved beyond a reasonable doubt that your client was under suspension at the time, correct?
Yes, Judge.
Okay, so he's currently under suspension, that's part 1B. Did he have authorization to be on the part of the campus that he was trespassed for being on?
No, Judge, he didn't have authorization, but
Strictly told that he couldn't leave where he was, so his authorization to be on campus was limited to the office that he was in at that point, correct?
That's correct.
So why wouldn't that be a reasonable reading of the statute that says that if he doesn't have authorization to be on school property and is under suspension, that he's in violation of 810-097?
Well, the first issue is the information charged under 1A. So the issues about the suspension don't come into play here. But as to restricting him and holding him there, the two elements have to happen contemporaneously. And so, yes, it could be a simple trespass or a trespass after warning, but going somewhere with authorization has to happen at the same time as the first element, which is to enter onto school property. He had already been on school property that morning all day. He entered school property in the morning. By stepping from the dean's office to right outside the dean's office, that's all on school property. There's no entry onto school property at that time.
But I thought you just said in answer to Judge Evander's question that the school could limit its authorization to certain places on the campus. It couldn't, under the statute.
Yes, I definitely agree that they can limit where the student can go, but that doesn't mean that the actions that were taken here and what's on the record constitutes a trespass upon school grounds. That's what he was charged with. Those are the elements that have to be on the record. It could have been a simple trespass. It could have been a trespass after warning, but it's not a trespass upon school grounds because those two elements have to happen at the same time. He only entered the campus once
But
that
he
day.
remained, the statute provides for two things. He entered, which I agree with you on that. He came in the morning. He didn't leave and come back, even though he went to a different part of the campus. It says, or remains. Once he left the area where he was told to be, how does he then have authorization, or how does he then have business on the school grounds? He was charged under Section 1, which includes both. Somebody who doesn't have any legitimate business or authorization to be here, or a student under suspension. Once you're under suspension and told you stay right here, how do you have any legitimate business being anywhere other than, right outside the guidance counselor's office?
Well, he was instructed to remain on campus. Although he was instructed
Here,
to
though.
yes, Your Honor. He was instructed to remain in that room. So although he did step outside the room where he was instructed to stay, he was instructed to remain on campus. So it doesn't break it down into different sections of the campus or different rooms. It's the school property, and he was instructed to remain on school property, and he did remain on school property. Whether he went into a different room, then like I said before, that could be a trespass or a trespass after warning. That'd be akin to, say, a teacher has a classroom and she says, I'm going to go to another class and get something from a teacher. Stay in this classroom. And then at that time, some student steps out into the hallway to go to the bathroom. They leave the classroom. Under that same logic, that student's action would be a trespass upon school grounds. And that rationale just doesn't follow. The two elements have to meet up, and in this case, we don't have that.
But do you have a necessity aspect, and that is, you have the other case from the first DCA where a child's suspended, so then they have no right to be on campus at all, and the school says you need to go, and the appellate court says, no, you can't do that because you send a minor child away from school when there's no one, no adult to pick them up. So in this case, the school had to keep the child in the office until an adult picked them up. Would you agree with that?
Yes, Judge.
All right, so you kind of have a situation where once a child was suspended, they had no right to be on campus at all, but the school had to keep him there, until an adult came. So what would you expect the school to do in that situation? They can't, the child has no right to be there, but on the other hand, they can't remove the child until there's an adult to pick him up. So it seems like the school made a common sense decision to have the child remain in the office and not be elsewhere on the campus.
Yes, Judge, and I think that's what the school should have done, is had the child remain in the office. He did step outside the office for a couple moments, but then he stepped back inside the office, and he was compliant, and he was going to wait for his parent. That doesn't mean that he needs to be arrested and taken out in handcuffs and charged under 2 criminal statutes, including disruption of an educational institution. He was suspended for 10 days. The record shows that after this 10-day suspension, he was a model student. The dean even said that he helped her with other students, and that was a 5-month period. So from this suspension until the trial, both the dean that testified at trial and the SRO, the school resource officer, said that he had been well-behaved and helped out. So the 10-day suspension worked. It was effective, and that was what was reasonable. Not charging him under 2 criminal statutes and adjudicating him delinquent.
Do you want to save the rest of your time for?
Yes, please. Thanks.
May it please the court. My name is Nora Hall, and I represent the state of Florida in this matter. The state's position is that the state did establish that, and it was uncontroverted, that the appellant was suspended, and basically, when a child's suspended, they're trespassed from the school at that point. He's allowed to stay. He's given authorization to stay in the disciplinary office until his mother comes to get him because he's still under school jurisdiction. He's a minor child. They can't force him to leave the campus. In the affidavit of delinquency, the statute was charged under number 1. It included subsections A and B. And the trial court judge said that he applied subsections A and B. He is a student. He was suspended. He was trespassed. And, as a former middle school teacher, I can tell you some kids can do some really bad things in school. And I think it's against the school's interest to allow a suspended student who's trespassed to roam the halls at will. That's just not appropriate.
What does the term campus mean in 810-097?
I think it means that everything that's within the jurisdiction of the school.
So this student was under suspension, that's not disputed, and he was on campus. Was he in violation when he was in the office?
He was not in violation when he was in the office because he was authorized to be there, and he was still under the school's jurisdiction.
And say that there's a area of the school that's posted no students allowed, the teacher's lounge example. If a student wanders into the teacher's lounge and is caught there, is that student guilty of trespass under this section?
I wouldn't think so, because he's not a suspended student, and he's at school unless he's at school when he's not during school hours and he's not there for a legitimate purpose. If he's there during school hours and he wanders into the teacher's lounge, I would not think that that would be a trespass because he's not suspended and he's there for a legitimate purpose. The appellant was suspended for 10 days. His legitimate purpose had...
Really, the issue is the interpretation of subsection A, I think. I mean, if campus can mean a portion of the campus, then I don't know why a student who was not authorized to be in a particular portion of the campus couldn't be prosecuted if they were there when they weren't authorized, because they don't have to be under suspension to be prosecuted under this statute. So the question really is, does this term campus or other school property treat the facility as a whole, or allow the state to charge somebody if they wander into a section that's off limits where there's no authorization?
I that's conceivable that they could do that.
It's kind of like a convenience store. You know, you get, public's invited in a convenience store, but then you have a back office that says employees only, no
Right.
customers. Could you, you know, there is case law out there where you can charge someone for trespass for going into the place that's closed to the public, because the only place that's open to the public is where the merchandise is. So I think the question is defining campus the way it does that mean that the school can you know, say part of the overall area is open and part is not? And if someone goes in the part that's closed, if you would, to students, can they be prosecuted for trespass under that section?
It appears that they could.
And I think that's the argument that's being made, is not that this student couldn't have been prosecuted for trespass under a different section, trespass after warning, I warned you, you had to stay here, but that this section treats the campus or school property as a whole, and that it's not appropriate to prosecute somebody on this section if they just wander into a different area. And I don't hear a good response to that.
Let me make sure I understand you properly. That he can't be, you're saying he can't be prosecuted if he's in one section and wanders into another section.
Well, this says that you can prosecute anybody, forget the suspension, who does not have a legitimate business on campus and who enters and remains in campus when they're not authorized, licensed, or invited. Right?
Right.
So, I mean, if I went to the local middle school right now and bypassed the office and didn't sign in and didn't get whatever and walked onto the campus, I mean, I would be in violation of this statute, right?
You would be.
Yeah. So what authorizes or allows us to treat the term campus or school property as anything other than the entire campus? I mean, you might be able to get somebody who wanders into a certain section where they're not authorized under a different statute, but it seems like campus is pretty clear, and it seems like it's talking about the whole facility.
The state maintains that he was trespassed when he was suspended, and that he was given authorization to stay in the disciplinary office. He was not authorized to go outside of the office. And so when he did that, and he flagrantly,
It seems like under this, I mean, he was authorized to stay on the campus for longer
he was authorized to stay in the disciplinary
until
office.
they escorted him off. He was off, but he was, I mean, this doesn't say if you have a legitimate business in a disciplinary officer portion of the campus. It says the campus. And he was authorized, he was authorized to stay on the campus, right?
Right. So are you saying subsection B doesn't apply?
Yeah, it applies.
Okay,
I mean, he was under suspension, but
he was.
But they told him to stay.
But they did tell him to stay, but they told him to stay in the office and not to leave. And he also did it in the plain view of a deputy, so,
We're not saying he was behaving well or doing what he should have been, and I
Right.
don't think the appellant is either,
well,
but
he was charged with a misdemeanor, and so it was observed by a deputy. He was told to stay in there. They told him to come back and sit down, and he said, "Fuck you," and left anyway. And so,
And the argument is this statute's black and white. You either are allowed to be on campus or you're not allowed to be on campus. You're either on campus or you're not on campus, because the statute talks about business on campus. The statute doesn't talk about business in a particular office or business in designated portions of the campus. It says you either have legitimate business on campus or you don't. And I think the argument is that this student was authorized to stay on campus.
he was authorized to stay on campus.
A part of the campus, but this statute arguably doesn't allow you to, I mean, you're either allowed to stay on campus or not for purpose of this statute if it's talking about the entire campus, right?
Unless you're suspended. He's suspended. He's not allowed to stay on campus.
Well, then he
they
was,
told him to.
yeah, then he was in violation sitting in the disciplinary
But
office,
he's under the jurisdiction of the school. They can't kick him off the campus. He's a minor.
which is what the first DCA said in the other case. It said that you couldn't apply it that way.
But they said under the circumstances of that case, and it's a totally different set of facts. He was told to leave the campus as a 14-year-old when school had jurisdiction over him. The school did what they had to do. They had jurisdiction over him. They kept him in the disciplinary office until his mother arrived. And when he stepped outside the disciplinary office,
Could he have had his suspension lengthened for, I mean, it was clearly a violation of the Code of Student Conduct to disobey the assistant principal and not stay where you were told to stay, right? I mean, he could have been disciplined for that.
I'm sorry.
He could have been disciplined further, an additional day of suspension or something for not,
He could have been.
right? The question is whether it's criminal or not.
That's true. But I think there's a public policy issue here that's a lot more serious than this particular issue with this appellant. I think with the school security issues that we have today, that school trespass laws do not need to be weakened. Schools have enough trouble as it is keeping the grounds safe. And like I said before, some students can do some pretty serious things on a school campus. Do you really want to allow them to just roam at will?
You want us to read this as any person who does not have a legitimate business on the campus or any area of the campus designated by a school official.
That's the way it should read.
Okay, don't you think you might ought to talk to the legislature about that? Not us? I mean, so campus could, I mean, it seems like campus could be read to mean the entire facility, or it could be read, as I just discussed, to mean the entire facility or designated part. Do you agree with that? It could be read either way in this statute. I'm talking about statutory interpretation.
Yes, it could be read either way. And
So is it ambiguous?
I don't think it's ambiguous because what you said with the,
Reasonably read two ways, I mean,
but the school they have jurisdiction over all of their property, and it's up to the administration of the school to determine how the rules are applied within that facility. Some people are not, just like you said, there are some situations where people are not allowed to go into certain areas. I mean, there are all kinds of
that would
applications.
be a normal trespass. I mean, just like the convenience store example, right?
Right.
But it seems like this statute is designed to protect campuses as a whole, so that people who are not authorized can't set foot on the property at all, right?
I think it's authorized to protect the student body and the school from people who exhibit bad behavior at school. And I think it gives the school the option to remove that student from the school and to restrict where they can go until their parent comes to get them.
Under 1A, are they is the school allowed to set the limits of the authorization or license for the person to remain on the grounds?
Apparently they are, because it says that they can have, where they could be authorized or be licensed. I mean, it doesn't say that if you're authorized to be on the whole school. I mean, isn't that up to the administration of the school to give the authorization or the license or the invitation? They determine.
So they can set the terms of the authorization or the terms of the license, and if you don't abide by those terms, then you're not there with authorization?
Yes. Wouldn't that be the same application as the convenience store? You're invited to come in, but you're not invited into parts of the store.
So your position is that if I went to the local middle school and checked in at the office and I was speaking at a classroom, and they told me, okay, you're authorized to go directly to that classroom and come back, that if I took a side trip just to see another part of the school, I would be criminally liable under the statute?
Yes. I think you would. And I think that's for the protection of the school and for the students there, student body.
I understand your argument. Any other questions? Questions, anything else?
No, but the state would ask that you affirm the trial court's judgment. Thank you.
First of all, I'd like to address the weakening the school trespass laws. The decision here today and these statutes do not concern the school policies and how they police their students, or different policies about how they treat their students. Also, the child could have been charged under simple trespass, and it probably could have been proven according to the record, but he wasn't. He was charged under trespass upon school grounds, and all
Are you
the,
saying the child could have been charged under trespass of a structure?
he certainly could have been charged with trespass
Okay,
after warning. I'm not sure, probably a structure. I'm not sure about what the overhang or what exactly
well,
was outside.
Trespass of a structure statute doesn't divide it up. You know, it doesn't say part of a structure. So if a child went into the teacher's lounge, or say they went into a room with electrical equipment and says no students allowed, is it your position they could be charged under trespass of a structure but not trespass on campus?
Yes, Judge, that is my position.
And you would have to recognize that statute is just as general. It says structure. I mean, so you could make an argument that means an entire structure.
Perhaps, but a structure is more complicated and it's more nuanced, because you can break it down to different sections, like where before we were talking about convenience store, that you can't go in a certain area.
You can't break a campus down into different areas?
Perhaps you could, but it says the school property. The statute uses campus and it uses property. That's easily defined.
So is a structure. I mean, you look at a convenience store and I can tell you what the structure is and where it is, right?
Right, but in that case, we have a wall or an area that's chained off, and there's something that says that you can't go in that area. In this case, it would be a teacher could just make an invisible force field to say, stay within this 5 feet area. If you step outside, then you're guilty of trespass upon school grounds.
How about if you had a convenience store and you didn't have a sign up to the back office, but the employee said you can't go back into that office, that's just for employees. So you didn't have a sign, would that, and the person won anyway, would that be a trespass?
I believe that could be a trespass after warning. But for this statute in particular, there's not much jurisprudence, but what there is, it's clear that this is meant for a situation where somebody's not supposed to be on campus at all, or when they're there and they're asked to leave and they shouldn't be there. It's a student from another school coming to a school they don't attend to cause problems or something like that. Or it's a student that was suspended 5 days previous and comes to a football game or something like that.
Well, under section 1A, one of the terms there is whether the school gave authorization. Is the school allowed to set any terms and conditions of the authorization? You know, Judge Lawson gave the example of he's going there to speak at a class. Well, instead of going to speak at the class, he goes to the gym and shoots baskets. Or like a parent goes to the ball game, instead winds up in Mr. White's chem lab making meth. I mean, isn't the school allowed to set certain reasonable limits in its authorization?
Yes, Judge, they certainly are.
And here they set the limitation of, you stay right here until we're done, until your mom or dad comes and picks you up.
Right, but that would be a trespass. Under this statute, we still need the element of entry onto school property. Enter or remain.
He was authorized to remain on the property if he stayed where they told him to. That was the authorization. If he ignores that authorization and goes to the gym or goes out into the breezeway or whatever, is he still authorized to be there, to remain there? I mean, that's really kind of the question under 1A, isn't it?
Yes, Judge, but I'd argue that we still have to look at the campus as a whole. That it is, the statute, I believe, is pretty straightforward, and it's short and clear that it says to either enter or remain on school property, and that it's the school property as a whole that it would.
I agree with you. I don't disagree with you on that part, but the authorization, that phrase, he was only authorized to stay there if he stayed in a certain geographic area, and if he didn't do that, he was no longer authorized to remain there, was he?
No, Judge, and I think that would be a trespass after warning, not a trespass upon school grounds.
Did the petition allege a violation of section 1, or did it break it down to 1A or 1B, or did it just say 1?
Judge, the petition, when it stated the statute, it just said subsection 1, but the delinquency petition reads word for word 1A. It says, "Did enter or remain upon school property, to wit, Lee Middle School, and at the time of the offense did not have legitimate business or any other authorization, license, or invitation to enter or remain on the property of Lee Middle School." Because even under subsection B, there's an argument that he could even be...
Well, under 1A, can you limit authorization to a part of the campus?
Under 1A, it's my position that would not apply under 1A. That could apply under a simple trespass, that could perhaps even apply under 1B.
So just to boil it down, at the very basic, I mean, he was charged criminally for not having legitimate authorization to remain in or enter, actually it would be enter. So he didn't have legitimate authorization to enter school property. And the state's argument is that his authorization was limited to a portion of the property, so he wasn't authorized to enter the other portion, and yours is that you can't limit authorization under this statute. Is that?
Partly, and mainly it's that he entered school property once that day. That him stepping outside the office, he's not entering school property, because you can't enter a property that you're already on. That, and me stepping right here, I didn't just enter the courtroom. I was already in the courtroom. That logic doesn't follow.
But the remaining issue is also there. He was remaining at campus. That's really what it boils down to. Nobody cared about him coming in that morning. It was, he stayed there, but didn't follow the rules that they set down for him. And the question is, do they have the right under the authorization term to set those limitations?
I don't believe under trespass upon school grounds they do. I believe they could under simple trespass, trespass after warning, but it's my position that trespass upon school grounds, there's no reason to try to read into it more meaning than there is.
Okay, let me see if there are any other questions.
No.
Okay, thank you both for your argument. Call the next case.